Hi, it's John Kelly. In this module, we are going to discuss liability to users of financial statements, and in particular, liability of the auditor to users of the financial statements. And let me include a disclaimer right away. I'm not a lawyer, so if you really want to be sure of the legal impact of any of these things, see a lawyer. The second observation I would have is I find it really useful to actually read the court decision in these cases, because oftentimes I find that the reporting of the decision or the reaction to the decision is different from what the court actually said. And we will see that in the Caparo case, which we will discuss in a few minutes. First case I want to discuss is Ultramares versus Touche, which was decided in the United States in 1932 and was a tort case. And it was held in that case in the United States in 1932 that the shareholders could not sue the auditor because you cannot have a liability in tort for an indeterminate amount, for an indeterminate time, and to an indeterminate class. Now, we all know that now in the United States almost anyone can sue the auditor for almost anything, and that's because this case was promptly superseded by the concept of strict liability, which was introduced in the Securities and Exchange Act of 1934. So while it was an interesting decision and favorable to the auditors, it lasted only about a year or so. We then move forward to 1990 and to the Caparo case in the United Kingdom. And interestingly, in that case, they actually quoted Ultramares and relied on it and concluded that public company shareholders could not sue the auditor. And this was confirmed in Canada in 1997 with the Hercules case. And the conclusion was that auditors owe a duty to shareholders as a group for the purpose of assessing the stewardship of management. And the problem cited to exposing auditors to this large liability in the Hercules case said higher auditor insurance costs, and that was bad. Increased costs for auditors to protect themselves from liability, and that was bad. There was a thought that the supply of audit services would decrease. There was a thought that the cost of audit services would increase. And there was a thought that young people would not enter the profession because of the vast liabilities to which they were exposed. The next stop along the way is Bannerman versus Royal Bank of Scotland in the United Kingdom in 2005. And one of the things that had happened in the United Kingdom after Caparo was auditors had interpreted Caparo that it meant that no one could sue the auditor, when all it really meant was the shareholders as a group could not sue the auditor. And the conclusion in the Bannerman case was a banker could sue the auditor. And this was something of a very specific case because the auditor really did a bad audit, and the auditor kind of knew what was going on and kind of knew that the banker was going to be relying on the financial statements and did a bad audit. And the judge said, no, you owe a duty of care to the banker because you kind of knew what was going on. Now, there was a strong reaction by auditors to this in the United Kingdom because many interpreted this to mean that all bankers could always sue the auditor, which is, again, not what the judge said in the Bannerman case, but that was the perhaps over-interpretation that occurred. Now, the result in the United Kingdom was what was called a Bannerman clause. The report is addressed to the shareholders as a group only, which comes from Caparo. And the following sentence was added, and there are other sentences in the audit report, and there are other versions. This is the 2014 version, We do not, in giving these opinions, accept or assume responsibility for any other purpose or to any other person to whom this report is shown or into whose hands it may come, save where expressly agreed by our prior consent in writing. And there was some discussion about whether or not this was holed up in court, and in 2015 it was upheld in the United Kingdom, Barclays versus Grant Thornton. February the 18th. The Bannerman clause was upheld. The interesting thing was the auditor won based on the clause alone. The auditor said to the judge, "Read this clause, the banker cannot sue us," and the judge said, "You're right." Negligence was alleged by the banker, but it was denied by the auditor and never proven because they never got around that, never got that far in the case. The other thing the judge thought was significant was the bank was a sophisticated user. The judge thought that the clause, the Bannerman clause, had a legitimate purpose, which was to avoid litigation. Said that, if the auditor wants to avoid litigation, they can. The other interesting thing they said about the bank was that the banker was getting a free ride. They had not paid for the assurance. And I guess that Grant Thornton pointed out that in other circumstances where Barclays had wanted assurance, they had separately engaged Grant Thornton and paid Grant Thornton to obtain that assurance. So the judge said, well, you obviously knew that if you wanted assurance, you should ask for it and pay for it. In this case, you didn't, so you can't sue. So in the United Kingdom, at least, the shareholders can't sue the auditor, and because of the Bannerman clause, no one else can either. In Canada, under securities law, the shareholders can sue the auditor for the greater of last year's fee and $1 million. And $1 million, I guess, sounds like a lot of money to you and me, but in terms of the legal costs of suing an auditor, it's not very much. And there's a qualifier there, unless the financial statements were included in a prospectus. And if they were included in a prospectus, then the liability of the auditor is limited only by the amount raised in the prospectus. And that can be very much bigger than $1 million. So a very much oversimplified summary. In the United Kingdom, can public company shareholders sue the auditor? No, because of Caparo. Can a private company shareholder sue the auditors? Well, maybe, as long as the private company shareholders are not themselves in on the problem. Can other people sue the auditors, bankers and stuff like that? If there's a Bannerman clause, no. And the same for private company, other people. If there's a Bannerman clause, no. In the United States, everybody can sue the auditor. In Canada, can public company shareholders sue the auditor? No, because of the Hercules case. Same answer about private company shareholders, maybe, as long as they're not in on it. And public company others and private company others, can they sue the auditor? Maybe. So that then brings up the question of, should we have a limitation of liability paragraph in our engagement letter? And most insurers recommend that you do. And given that insurers recommend it, I don't know why you wouldn't. Several things you need to think about doing. Limit your liability to within 2 years after the service was provided. Why do you want to do that? Well, under tort, you normally have 2 years to sue after finding your loss. And that might be many years later, meaning that 10 or 11 or 12 years after the financial statements were completed, someone might try to sue the auditor. The other limitation of liability paragraph you might add is to say we wish to limit our professional liability to the amount of assurance we have available or to the fee, and that places a reasonable cap on monetary damages. You have to decide whether you want to do it based on the liability insurance you have available or the fee. And then no consequential loss of use. earnings and business interruption and others, and I don't quite understand those, but if lawyers tell you to put them in, I'm going to put them in. Now this deals with the contractual liability to the client, and these limitation of liability paragraphs have been upheld in court. The other thing you might do is consider Bannerman and have a report footer at the bottom of every audit, review, notice to reader report for this communication, together with the work done to prepare this communication, and for the opinions we have formed, if any. We accept and assume responsibility only to the addressee of this communication as specified in our letter of engagement, and that deals with the tort liability to everybody else. The engagement letter deals with your liability to the shareholders who've engaged you. Now, will any of this work? It certainly won't work if it's absent. And I guess that's the best reason. If it's absent, it won't work. If it's present, well, it might, and see your lawyer. So, thanks for listening.